Hello, everybody, and welcome to Law Bite number 122, dated December 3rd, 2020. I'm Walter, your mobile historian and blue-collar scholar. This Law Bite is entitled McDonald versus City of Chicago, 561 U.S. 742, 2010. For those not familiar with this case, this was the landmark 2010 U.S. Supreme Court decision, which incorporated the Second Amendment personal right to keep and bear arms inside the home for self-defense to the states via the 14th Amendment to the U.S. Constitution. D.C. versus Heller was therefore expanded in its reach by McDonald versus City of Chicago, but the scope of D.C. versus Heller was not. And what I mean by that, quite simply, as more jurisdictions were covered, essentially, under the rationale of D.C. versus Heller by way of McDonald versus City of Chicago, but additional protections were not granted via McDonald versus City of Chicago, which is why I say the reach of D.C. versus Heller was expanded, but not the scope or effects of the decision per se. Okay? Now, after D.C. versus Heller was handed down, it was clear that the decision applied to federal jurisdictions, but what about the states? Indeed, that remained an open legal question until McDonald versus City of Chicago in 2010. Okay? So what happened in that case? Well, a group of Chicago gun owners filed suit against the city's very draconian and very restrictive gun laws that arguably weren't that different from those in the District of Columbia. Okay? Quite arguably, Chicago's might have been even stricter, depending on how you look at it. Okay? And the petitioners argued, that the laws in the city of Chicago quite simply violated the Second Amendment to the U.S. Constitution as interpreted in the case of D.C. versus Heller in 2008. Okay? And unfortunately, much the same as D.C. versus Heller, the district court dismissed the suits, in their entirety, And the U.S. Court of Appeals, unlike in D.C. Versus Heller, the U.S. Court of Appeals for the Seventh Circuit affirmed the district court dismissal. So afterwards, an appeal was taken to the Supreme Court of the United States. And a very simple question was presented to the justices. That being, does the Second Amendment's protection, the right to keep and bear arms, in the home for self-defense, apply to the state governments via the 14th Amendment? And by that, of course, we mean either via its due process clause, the traditional avenue of incorporating the Bill of Rights to the states, or its privileges or immunities clause, another possible avenue of incorporation that has technically never been used to do so. Petitioners at the Supreme Court here argued absolutely that the Second Amendment's right to keep and bear arms, home for self-defense, does indeed apply to the states, either via the 14th Amendment's due process clause or its privileges or immunities clause. And respondents argued, of course, that it did not, challenging every single assertion by the petitioners here, An interesting move by the petitioners that had not been done in who knows the amount of years was that the petitioners here asked the court to effectively overrule the slaughterhouse cases from 1873, which indeed had more or less foreclosed on the ability to incorporate any of the Bill of Rights to the states via the 14th Amendment's privileges or immunities clause. Have you heard of that? Now, I'm pretty sure you've heard of the 14th Amendment's due process clause. Indeed, everyone's heard of that, most likely. But the privileges or immunities clause, maybe not so much. And that's unfortunate. Not that you haven't heard of it. What's unfortunate is that the Supreme Court effectively gutted it of most meaningful use very early in its history, just 5 years after its adoption, okay, in the 14th Amendment in 1873, okay. When the 14th Amendment went into effect in 1868, a lot of people assumed that the Privileges or Immunities Clause was intended to incorporate the Bill of Rights to the states, okay, and that matter is very debatable. I don't personally believe that it was, but many do, and, you know, many did at that time, but slaughterhouse cases of 1873 pretty much ruled that out. But not to get too far off subject, so the petitioners argued that, you know, the right to keep and bear arms for self-defense in the home protected by the Second Amendment was protected by the states. Was applicable to the states via the 14th Amendment, okay? And the respondents for the city of Chicago argued that it wasn't, not at all applicable to the states, and by virtue of that, their local governments, okay? The case was submitted, and the Supreme Court, as it had done in D.C. versus Heller 2 years earlier, once again split along ideological lines in a 5-4 decision. The court ruled 5-4 that indeed the 14th Amendment did and was to incorporate forevermore the Second Amendment's right to keep and bear arms in the home for self-defense to the states via the 14th Amendment. The majority opinion written by Justice Samuel Alito held that the Second Amendment's right to keep and bear arms in the home for self-defense was indeed a right that was fundamental to this nation's scheme of ordered liberty, okay? It is something that has a long history and tradition, okay, in this nation, and is appropriately applied to the states via the 14th Amendment, okay? It was a deeply rooted right. Justice Alito, however, used the traditional method of incorporation, the Due Process Clause, okay? The Due Process Clause, like I said, essentially protects rights that are deeply rooted in the history and tradition of this country. Deeply rooted. Rights that go back hundreds of years, okay? So there's no argument about that, okay? However, and interestingly enough, okay, Justice Clarence Thomas did not go along with this. He wrote a powerful concurrence, where he argued that the Privileges or Immunities Clause of the 14th Amendment was the better avenue to incorporate the right to keep and bear arms to the states, logically because it was one of the privileges or immunities of American citizenship, okay? Essentially one of the privileges of American citizenship, the right to own guns, okay? Owning guns, obviously, was very important. So, Thomas argued that it was a unique privilege to be able to own guns, a privilege that was given to you by virtue of you being born an American, all right? Though he didn't naturally view Alito's usage of the Due Process Clause as faulty, per se, but he argued, okay, most adamantly that the Privileges or Immunities Clause was the better avenue because essentially to Thomas, this and likely other aspects of the Bill of Rights are essential and ordered and fundamental privileges of American citizenship, even though technically, such provisions aren't limited to just Americans. So that might weaken just a little, might weaken that concurrence that owning the right to keep and bear arms was something solely a privilege of American citizenship, as the Bill of Rights, the protections in the Bill of Rights do not limit themselves to American citizens. And in reading the 14th Amendment's Due Process Clause and Privileges or Immunities Clause, you see that the Privileges or Immunities Clause limits itself to American citizens, whereas the Due Process Clause and the Equal Protection Clause include everybody in the state. Okay, so it was a very important distinction to be made, and Justice Thomas has arguably revived the Privileges or Immunities Clause for potential usage down the road in other cases, as he boldly asserted that that was the better avenue to incorporate than the 14th Amendment's Due Process Clause. Okay, Justice Thomas is not a big fan of substantive, of using the due process clause for a great deal of things, but that's okay. He argued, like I said, logically that the privileges or immunities clause made the greater case. And Justice Alito's majority opinion, of course, rejected that because the Supreme Court itself had rejected that way back in 1873 in the slaughterhouse cases. Okay? On the dissenting side, Justice John Paul Stevens argued quite naturally, as you would expect in this case, that the right to keep and bear arms was not in any way, shape, or form a personal liberty interest that would be protected by the due process clause. Okay? And, regulations of firearms by the state governments was certainly not out of the question and certainly not inhibited by the 14th Amendment's due process clause, certainly with respect to the city of Chicago. Okay, he said, and quote, that the text, history, or rationale of the Second Amendment in general as a provision, nothing within those guidelines, nothing in the text, history, or rationale of the Second Amendment characterized the right to keep and bear arms as a fundamental right or personal liberty that deserved incorporation to the states via the 14th Amendment. Okay, so, all right, from this case, okay, in sum, the Second Amendment's right to keep and bear arms in the home for self-defense was incorporated to the states via the 14th Amendment's due process clause and loosely, by implication, via Justice Thomas's concurrence. Okay? There may be arguments made also that it is possible that the privileges or immunities clause has also been invoked to accomplish this purpose. But for simple reference purposes, this case utilized the 14th Amendment's due process clause to incorporate the Second Amendment right to keep and bear arms, okay, to the states, okay? It had not been made applicable to them before this time, okay? This case incorporated the Second Amendment to the states, the sum of it all, the bottom line. And for reference purposes, I will give you the full text of the Second Amendment to the Constitution, which reads, and I quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Okay, so that's the sum of the case of McDonald versus City of Chicago, 561 U.S. 742, 2010. If you have any questions or controversies, please leave them down below. I'll be happy to answer them. And if you have not subscribed to my YouTube page, please do so now. It would be greatly appreciated. Just hit that little red button and we are in business. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.